Chapter 1. Oregon Department of Agriculture, ODA. Pesticides Program. The Oregon Department of Agriculture is the primary state agency responsible for pesticide regulation. Three core activities of the ODA pesticides program are to register pesticides and ensure the safe use through education and assistance, certify and license pesticide applicators, pesticide consultants, pesticide apprentices, pesticide operators, and pesticide dealers, carry out enforcement activities regarding licensing, pesticide sales and distribution, and pesticide use. Pollinator protection. ODA also is involved with implementing certain parts of the Worker Protection Standard. The pesticides program works cooperatively with the United States Environmental Protection Agency, USPA, in regulating the production, distribution, registration, and use of pesticides in the state. Oregon Revised Statute Chapter 634, or 634, the Oregon Pesticide Control Law, was created by legislation granting authority for pesticide regulation in Oregon to ODA. To implement this statute, ODA develops specific rules, which are contained in the Oregon Administrative Rule. Chapter 603, Division 57, or 603 to 57, Pesticide Control. These laws, statutes and rules, form the foundation for ODA's activities in pesticide regulation and control since 1953. The Oregon Pesticide Control Law, or Chapter 634. The Oregon Pesticide Regulations, or Chapter 603 to 57. Registration of pesticides in Oregon. Each pesticide product distributed, sold, or offered for sale in Oregon must be registered with ODA annually. ODA has 4 types of pesticide registrations, which are classified according to specific sections of the federal law, the Federal Insecticide, Fungicide, and Rodenticide Act, FIFRA. Section 3, often referred to as the Federal Label or Container Label. Section 24, C, also called a Special Local Needs Label or SLN. Section 18, also called an Emergency Exemption, and 25B, Minimum Risk, pesticides that are exempt from federal registration, but not state. Section 3 registrations and the associated labels are reviewed and accepted by EPA. The label will bear the EPA registration number and must be attached to each pesticide container. More information about Section 3 registrations and labels are covered in the National Core Manual. Under FIFRA Section 24, C, under certain conditions, states are authorized to grant special local need, SLN, registrations. ODA may grant a SLN registration for the use of a pesticide on a crop, when a pest is causing serious damage and there are no currently registered pesticides that will adequately control the pest. The SLN or 24C label may have additional sites, increased rates of application, a change in the frequency of applications, or how the pesticide can be applied. If the site is a food or feed crop, the pesticide must have an existing tolerance set by the EPA on that particular food or feed crop. The registrant or industry group may request an SLN and provide supporting data to ODA. The data must show that the product will control the pest and not cause harm to the treated crop, wildlife, or the environment. Issues regarding potential applicator or worker pesticide exposure must also be addressed before the SLN is granted. Applicators using a pesticide under an SLN label must follow all directions on the SLN label and the main pesticide container label, FIFRA Section 3. Since the SLN label allows a person to use the product in a manner different from the Section 3 label, the applicator must have a copy of the SLN label in their possession at the time of application. FIFRA Section 18 emergency exemptions may be issued by EPA when there is a new pest emergency that will cause significant economic loss in situations where there is no currently registered pesticide or method to control it. It is the only time when EPA will allow an active ingredient they have not registered to be used. ODA must submit petitions to EPA that provide data showing a compelling and significant difference between control provided by the standard pesticide used and the proposed pesticide. Section 18 exemptions may be granted when there is no established general pesticide residue tolerance. However, EPA will establish a time-limited tolerance. Section 18 exemptions are for a specific number of acres that may be treated and may be valid for up to 1 year, and they must be used according to the label directions. The Section 18 label must be in the possession of the user at the time of application. FIFRA Section 25B minimum risk pesticides contain specific active and inert ingredients that EPA considers low risk. These products are exempt from federal registration, but products sold or distributed in Oregon must be registered annually with ODA. Pesticide Stewardship Partnership Program, PSP. The PSP is a program coordinated through ODA, and designed to reduce the potential Environmental impact of pesticides on Oregon's water bodies, and the organisms that depend on these habitats. The PSP program uses local expertise, combined with pesticide monitoring data to encourage voluntary changes in pesticide use and practices, which result in measurable improvements in water quality for aquatic life and humans. The PSP program is administered through the Interagency Water Quality Pesticide Management Team, WQPMT, comprised of members from Oregon Department of Agriculture, ODA, Oregon Department of Environmental Quality, DEQ, Oregon Department of Forestry, ODF, Oregon Health Authority, OHA, Oregon Watershed Enhancement Board, OWEB, and Oregon State University, OSU. Stewardship Partnerships in Action. There are currently 9 designated PSP projects in Oregon: Amazon Creek, Clackamas, Hood River, Middle Deschute, Middle Rogue, Malalapudding, Wasco, Walla Walla/Milton Freewater, Yamhill. The WQPMT developed the Pesticide Management Plan for Water Quality Protection in May 2011. This plan, approved by the U.S. Environmental Protection Agency, is designed to protect water quality from pesticide impacts. The plan provides for the designation of priority pesticides that could affect water quality, and provides for the evaluation of current and historic water quality monitoring data and the cooperative development of management measures to address pesticides of concern both at the watershed and statewide level. In 2013, the legislature allocated stable funding for the Pesticide Stewardship Partnership. Additional information regarding the PSP program and the WQPMT can be found on the ODA website. Pesticide Collection Events. ODA and DEQ work with PSP partners to conduct waste pesticide collection events in various locations throughout the state. The purpose of these events is to reduce the risk of accidental release of unwanted or unusable pesticides into surface or groundwater. The program provides a no-cost, legal disposal option for pesticide users to dispose of pesticides where the container is damaged and/or the label is unreadable, the pesticide is no longer registered for use, or is unwanted due to changes in farming practices. Disposal of unusable or unwanted pesticides and their containers through this program ensures compliance with state and federal hazardous waste regulations. These collection events are usually for farmers and private landowners. There may be a nominal fee for businesses, AG retailers, and for larger quantities. Empty, triple-rinsed plastic containers are also typically collected for recycling at these events. Collection events can be found at https://oda.direct/pesticide stewardship. Pesticide Analytical and Response Center, PARC. The Pesticide Analytical and Response Center, PARC, was created by executive order in 1978. The program was reauthorized under the Oregon Department of Agriculture, ODA, as Oregon Revised Statute, ORS, 634.550, in 1991. PARC is mandated to perform the following activities with regard to pesticide-related incidents in Oregon that have suspected human/animal health or environmental effects. Collect incident information. Mobilize expertise for investigations. Identify trends and patterns of problems. Make policy or other recommendations for action. Report results of pertinent investigations, and prepare activity reports for each legislative session. PARC does not have specific regulatory authority of its own. Rather, PARC functions to coordinate its member agencies' activities to collect and analyze information about reported pesticide-related incidents. Investigation coordination includes collecting reports produced by member agencies and consultation as necessary with toxicologists of Oregon State University and the Oregon Health Sciences University. Other governmental bodies may also participate in the reporting or investigation of an incident. The 8 member agencies include the following: Oregon Health Authority, OHA, Oregon Department of Fish and Wildlife, ODFNW, Oregon Department of Environmental Quality, DEQ, Oregon Department of Forestry, ODF, Oregon Occupational Safety and Health Administration, or OSHA, Office of the State Fire Marshal, SFM, Oregon Poison Control Center, OPC, and Oregon Department of Agriculture, ODA. IPM in schools. The school IPM law became effective July 1, 2012. IPM is a common-sense strategy that integrates multiple tactics to reduce pest populations to an acceptable level. Strategies include sanitation, pest exclusion, cultural practices, biological control and mechanical control while limiting the use of chemicals. IPM weighs the risks and benefits of pest reduction methods to determine the most environmentally and economically Sound manner to manage pests. The law addresses the implementation of integrated pest management, IPM, practices in schools and requires all Oregon pre-kindergarten, public, and private K-12 schools, community colleges, federal Head Start programs, Oregon School for the Deaf, Oregon Youth Authority, residential academy, and education service districts to implement IPM practices as well as other requirements. Oregon Revised Statutes, ORS, 634.700 to 634.750. There are a number of requirements mandated by the law, including that pesticide applications on public or private school property, K-12 and community colleges, need to be conducted by a licensed pesticide applicator. Applications of disinfectants and insecticidal soap are exempt from the school IPM requirements. Under the school IPM law, if an individual is an employee of a public school, he or she must have a public pesticide applicator license. If an applicator is an employee of a private school, he or she will need to have a commercial pesticide applicator's license. Schools also have the option of hiring a licensed commercial pesticide applicator, employed by a pest control company, to make any necessary pesticide applications. Public school employees, the new IPM in schools law, or 634.700, now requires a public pesticide applicator license, apprentice, or trainee license for every public school employee applying pesticides, except antimicrobials or insecticidal soaps. Apprentices and trainees must work under the supervision of a fully certified and licensed applicator. Private school employees, employees of private schools must have a valid commercial pesticide applicator license to apply any pesticide, except antimicrobials or insecticidal soaps, to private school property. Apprentices and trainees must work under the supervision of a fully certified and licensed applicator. Companies contracted to conduct pesticide applications on school property. If a company is hired to apply pesticides on school property, the company must be licensed as a commercial pesticide operator, and each individual applicator, person, must be licensed as either a commercial pesticide applicator, apprentice, or trainee. The licensing status of the company, an applicator, including apprentices or trainees, should be verified by checking the ODA website, https://oda.direct/about-pesticides. The school IPM law has specific notification and record-keeping requirements, and limitations on what pesticides can be used. A school's governing body is responsible for plan development and implementation. For additional information about the IPM in school law, please see ORS 634.700 to 750 or visit the website listed above and click the Licensing Information tab and then click on the Integrated Pest Management, IPM, in Schools link. Oregon Department of Environmental Quality, DEQ. The Department of Environmental Quality is the primary agency involved with environmental regulation in Oregon. The DEQ administers rules governing the management of pesticide residues, waste pesticide disposal, pesticide spill cleanup, and empty pesticide container disposal. The DEQ also issues National Pollution Discharge Elimination System (NPDES) permits for pesticide applications made to, over, or near water. The DEQ regulates all pesticide residues declared hazardous wastes. As used in this section, the term residue means any leftover pesticide that may need to be disposed of, such as banned pesticides, unusable or leftover pesticides, pesticides that have been damaged, etc. It does not pertain to pesticide products lawfully applied to target sites, including crops, or the remaining residue after a pesticide has been lawfully applied to a target site. Impact of law: pesticide residue waste. Impacted by law, applicators who either discard or abandon pesticide residues or accumulate pesticide residue on site must manage and dispose of pesticide waste under the regulations in OR 340-109-0010. Not impacted by law, pesticide applicators do not trigger waste management regulations. When legally using a pesticide according to label use directions, and in accordance with state and federal laws. This includes using pesticide container rinse water, or diluted pesticides. For more information, contact the Oregon DEQ. Pesticide wastes. When pesticide products are banned, phased out, damaged or unusable, the resulting wastes often accumulate for years because of the lack of cost-effective or convenient disposal options. Product waste containers degrade over time, increasing the risk of pesticide releases into the environment. Oregon regulations, OR 340-109-0010, require some basic management practices and labeling for waste pesticides. Collecting these wastes is part of DEQ's toxic reduction strategy. Pesticides collected during waste collection events can be handled in a number of ways, including in some specialized situations being handled under the Resource Conservation and Recovery Act, RCRA. RCRA was enacted in 1976 and is the principal law in the United States that regulates solid and hazardous waste, which includes pesticides, pesticide spill cleanup and pesticide waste. The United States Environmental Protection Agency, US EPA, administers this law on a national level. In Oregon, it is administered by DEQ. As a result of this law and the matching regulations, many chemicals, including pesticides, may be considered hazardous wastes. Under this RCRA, the person who produces hazardous waste is responsible for proper handling and disposal of the waste. To find out more about managing pesticide container residues and decontaminated containers, see OR 340-109-0001, Division 109, or contact the Hazardous Waste Management Program within DEQ. Empty container disposal. Rigid pesticide containers, plastic, metal, and glass, should be decontaminated, rinsed, and, if possible, reuse the rinse water for pesticide application or mixing. Decontamination of rigid containers consists of removing any residual pesticides by jet or multiple rinsing. Pesticide containers should not be punctured or crushed unless they have been decontaminated. Never puncture or crush glass containers, take them to a waste pesticide collection event. Pesticide containers that are punctured and crushed are by definition decontaminated. Decontaminated pesticide containers are not hazardous waste and may be recycled at a collection site or event, or disposed of at a landfill. Empty non-rigid pesticide containers, including paper, paper laminated, and paper laminated foil bags, may be 1. Disposed of in a permitted solid waste landfill, or 2. Burned in an incinerator or boiler, which has been permitted by DEQ to burn this type of waste. Decontamination methods may be different based on the type and size of container, and if the container has been designated as a returnable/refillable container that is intended to be returned to the retailer for reuse. For more information on managing pesticide waste and container management, contact DEQ or see Chapter 340 Division 109, Management of Pesticide Waste. National Pollutant Discharge Elimination System. NPDES. The NPDES permit program controls water pollution by regulating point source discharges of pollutants into waters of the United States and authorized by the Federal Clean Water Act of 1972. An Oregon NPDES pesticide general permit is required by a federal court order for certain pesticide applications, in, over, or near waters of the state. It is implemented in Oregon by the Department of Environmental Quality, DEQ, under an agreement with the U.S. Environmental Protection Agency, EPA. The Pesticide General Permit, PGP, specifically regulates pesticide applications in, over, or near water to control the following: mosquitoes and other flying insect pests, weeds and algae, nuisance animals, forest canopy pests, other pests that must be controlled under area-wide programs. All individuals, businesses, and property owners responsible for pesticide applications in the 5 categories listed above must comply with certain basic requirements of the permit. A higher level of permit conditions is required for all federal and state agencies, weed and vector control districts, and for certain other entities that exceed annual treatment area thresholds defined by DEQ. For more information, contact the DEQ. Oregon Occupational Safety and Health Administration, or OSHA. OSHA is the agency that enforces most worker protection laws in Oregon, and it addresses all areas of worker safety on the job. The Worker Protection Standard, WPS, for pesticides, and the Oregon Hazard Communication Standard, HCS, are both administered by OSHA. OSHA also addresses pesticide storage compliance, emergency first aid including the provision of an emergency eye wash, decontamination supplies. Since WPS required that employers provide clean water, soap and disposable towels for pesticide decontamination, OSHA does not consider hand sanitizer as an effective way to remove pesticides from the skin. Supervision by the employer as it pertains to the employees engaged in activities such as pesticide handling, transportation of pesticides, wearing and properly maintaining personal protection equipment, PPE, use of personal protection equipment including respiratory protection, and the specific rules associated with the use of fumigants and the fungicide Thiram. The Hazard Communication Standard, HCS, applies to all employers. It requires employers to have a written hazard communication program, A labeling system, for secondary containers, including the name of the pesticide and signal word, and safety data sheets, SDS, previously called Material Safety Data Sheets. MSDS. Employee information and training to inform employees of the physical and health hazards, and the emergency procedures for the chemicals found in their workplace. EPA's Worker Protection Standard Regulation. 40 CFR Part 170. Please note, the information about the Worker Protection Standard, WPS, below reflects the EPA's federal-level version of the WPS and also Oregon OSHA, current at the time of publication. Applicators and employers of handlers and workers should check Oregon OSHA's website, www.orisha.org, for additional details about the requirements in Oregon. WPS is intended to reduce the incidence of occupational pesticide exposure and related illnesses and injuries among agricultural workers and pesticide handlers covered by the rule. The WPS requires employers to provide agricultural workers and pesticide handlers with certain protections. Who is responsible for providing the protections? Agricultural employers on agricultural establishments, which are defined as any farm, forest operation, or nursery engaged in the outdoor or enclosed space production of agricultural plants and will be referred to in this document as agricultural establishments. Commercial pesticide handling establishment employers, which are defined as any enterprise, other than an agricultural establishment, that provides pesticide handler or crop advising services to agricultural establishments. Examples include aerial application companies, field application companies, etc. Who is protected? Workers, those whose work activities are directly related to the production of agricultural plants on an agricultural establishment. Pesticide handlers, those employed by an agricultural employer or commercial pesticide handler employer and perform tasks directly or indirectly related to pesticide applications. Any other person on agricultural establishments during pesticide applications and while the restricted entry interval, REI, is in effect. When does the rule apply? This regulation applies whenever a pesticide product label contains the agricultural use requirements box, which requires compliance with the Worker Protection Standard, WPS. When used in the production of agricultural plants on an agricultural establishment, including retail outlets such as garden centers. The WPS does not apply on agricultural establishments when pesticides are used as follows. As part of government-sponsored public pest control programs over which the owner, agricultural employer, and handler employer have no control, example mosquito abatement, Mediterranean fruit fly eradication programs, etc., or on plants other than agricultural plants, which may include plants in home, fruit and vegetable gardens, home greenhouses, and permanent plantings for ornamental purposes, such as plants that are in ornamental gardens, parks, public or private landscaping, lawns, or other grounds that are intended only for aesthetic purposes, or for control of vertebrate pests, unless directly related to the production of agricultural plants, or when the product does not bear the agricultural use requirements box. Pesticide labels differentiate between agricultural use requirement boxes, which contain information for WPS, and non-agricultural use requirement boxes, which contain non-WPS pesticide safety information. Below is an example of a non-agricultural use requirement box. The agricultural establishment is responsible for the following protections. Annual pesticide safety training for workers and handlers, with no grace period. Providing personal protective equipment, PPE, as required on product labeling. Oral and posted notification of worker entry restrictions. Employer information exchange. Availability of hazard communications materials and pesticide safety information. Certain entry restrictions during application for outdoor production, including an application exclusion zone, AEZ, which varies depending on the type of application, and providing decontamination supplies. Annual training. Before any worker performs any task in a treated area on an agricultural establishment, and within the last 30 days, either a pesticide product has been used, or a restricted entry interval for such pesticide has been in effect, the agricultural employer must ensure that each worker has been trained. Restricted entry interval, REI. The restricted entry interval, REI, is the time immediately after a pesticide application when entry into the treated area without the proper early entry personal protective equipment, PPE, stated on the pesticide label is restricted. REIs can vary in length. For instance, some pesticides may have 1 REI, such as 48 hours, for all crops and uses, including methods of application. Other Pesticides have different risks depending on the crop, method of application, or the post-application activity to be performed. When two or more pesticides are applied at the same time and have different risks, the longer REI must be followed. The REI is listed on the pesticide label under the heading Agricultural Use Requirements in the Directions for Use section of the pesticide label, or next to the crop or application method to which it applies. Because the REI can vary depending on the pesticide being used, it is important for agricultural employers to consider the REI when making decisions about scheduling maintenance, weeding, irrigation or other activities which may involve workers entering treated areas. Personal protective equipment, PPE. PPE includes specific clothing and safety equipment that is worn to protect the body from contact with pesticides or pesticide residues, including, but not limited to, coveralls, chemical-resistant suits, chemical-resistant gloves, chemical-resistant footwear, respirators, chemical-resistant headgear, and protective eyewear. Agricultural employers are responsible for supplying workers and pesticide handlers with the PPE listed on the label. Application Exclusion Zone, AEZ. The Application Exclusion Zone, or AEZ, is a new term used in the WPS rule and refers to the area surrounding the pesticide application equipment that must be free of all persons other than appropriately trained and equipped handlers during pesticide applications. In Oregon, the Oregon Occupational Safety and Health Administration, or OSHA, administers the AEZ. In 2018, OSHA finalized state-specific rules pertaining to the AEZ that are described below. How are the AEZ sizes determined and measured? The AEZ is measured from the application equipment and moves with the application equipment, like a halo around the application equipment. The size of an AEZ varies depending on the type of application and other factors, including droplet size and height of nozzles above the planting medium. The AEZ is 100 feet for aerial, air blast, fumigant, smoke, mist and fog applications, as well as certain other spray applications using very fine droplet sizes, unless the pesticide label requires the use of a respirator. The AEZ is 150 feet and the area must be evacuated for a minimum of 15 minutes. An AEZ of 25 feet is required when the pesticide is sprayed using medium or large droplet sizes from more than 12 inches above the plant medium, and not applied aerially or by air blast spray equipment. An application that does not fall into one of these categories does not require an AEZ. See the OSHA decision matrix on page 21. What are the agricultural employer's responsibilities related to pesticide applications and AEZ requirements, and what are the effective dates of these requirements? The agricultural employer has two responsibilities related to pesticide applications and the new AEZ requirements. During any WPS-covered pesticide application whose pesticide label requires the use of a respirator, the agricultural employer must keep workers and all other persons, other than appropriately trained and equipped handlers involved in the application, out of the treated area and the AEZ within the boundary of the agricultural establishment. If the pesticide label does not require the use of a respirator, workers and other persons have the option of sheltering in place. See additional OSHA materials later in this section. Does the agricultural employer have WPS responsibilities related to the new AEZ requirements if workers or other persons are off his/her establishment? Starting in January 2018, all handlers performing an application must immediately suspend the pesticide application if any worker or other person, other than an appropriately trained and equipped handler involved in the application, is in the AEZ, regardless of whether such persons are on or off the establishment. If persons within the AEZ are off the establishment, the handler may continue with the application once they have determined that the pesticide will not contact these persons either directly or through drift. The AEZ requirement imposes no responsibilities on an agricultural employer regarding to workers or other persons who are not on his or her agricultural establishment, as long as the agricultural employer is not the pesticide applicator. However, if the agricultural employer is also the pesticide applicator, then WPS would require him/her to suspend a pesticide application if any worker or other person is within the AEZ but beyond the boundary of the agricultural establishment. Notice, starting in 2020, EPA is evaluating possible rule changes to the AEZ off the agricultural establishment. Notification, oral and posted notification of treated areas. Agricultural employers are required to post a warning sign if the REI is greater than 48 hours for outdoor applications, or greater than 4 hours for enclosed spaces such as greenhouses. Otherwise, oral or posted notifications are optional, unless the label requires both. Oral notification must be provided in a manner the worker can understand, before the application or at the beginning of the first work period. Notifications must include location and description of the treated area, the time during which entry is restricted, and instructions not to enter treated area. Pesticide information display and record keeping. Requirements. Pesticide safety, application, and hazard information. When must information be made available and what records must be kept? Agricultural employers must display specific information at a central posting location whenever any worker or handler they employ is on their agricultural establishment if, within the past 30 days, either a WPS-labeled pesticide product has been applied, or a restricted entry interval, REI, for such a pesticide has been in effect. The display requirements do not apply to commercial pesticide handler employers, but must communicate specific information to the agricultural employer. See Employer Information Exchange section. The following safety information must be displayed at an agricultural establishment's central posting location that is readily accessible to workers and handlers at all times during normal work hours. Pesticide safety information, which can be presented as either a poster developed by EPA, or other equivalent way of providing the required WPS pesticide safety concepts on the EPA poster. Pesticide application information including name of the pesticide applied, active ingredient, S, EPA registration number, REI, crop or site treated, location and description of the treated area, S, and date, S, start and end times of the application. Hazard information consisting of a copy of the pesticide product safety data sheet, SDS, formerly called Material Safety Data Sheet, MSDS. In addition, the pesticide safety information, EPA poster or equivalent, must be displayed at the following locations, in addition to the central posting location: any permanent decontamination site, and any location where documentation supplies are required for 11 or more workers. When must information be displayed? The information must be displayed within 24 hours after the end of the application, and continue to be displayed for 30 days after the end of the application or end of the REI, whichever is longer. The information does not need to be displayed if workers or handlers are no longer on the agricultural establishment. How is notification of treated areas different than display of pesticide safety information? The display of pesticide safety information is required in addition to posting of treated areas. The display is designed to provide application information for workers, handlers, and other persons on agricultural establishments. Keep in mind that display of safety information is contingent on a pesticide product having been used within the last 30 days, or a restricted entry interval for such pesticide has been in effect on the establishment within the last 30 days. Pesticide application records. According to federal law, if the pesticide application and hazard information is required to be displayed, the agricultural employer must keep a record of the pesticide application and hazard information on the establishment for 2 years from the expiration date of the REI of the pesticide. Pesticide records must be maintained for any covered use of a WPS-labeled pesticide for either general use or restricted use pesticides, even if state or tribal laws do not require pesticide record keeping. Employer Information Exchange. Before any application, commercial pesticide handler employers such as aerial application companies must make sure the owner/operator of an agricultural establishment where a pesticide will be applied is aware of location and description of area to be treated, date of application, estimated start time and estimated end time of application, product name, EPA registration number, active ingredient, S, and REI. Whether the product label requires both oral warnings and treated area posting, and all other safety requirements on labeling for workers or other people. Owners/operators of agricultural establishments must make sure any commercial pesticide handler employer they hire is aware of specific location and description of any treated areas where an REI is in effect that the commercial handler may be in or walk within 1/4 mile of, and the restrictions involved in entering those areas. Access to pesticide application and hazard information by a designated representative. Any worker, handler, or their designated representative may request access to, or a copy of, any information required to be retained for 2 years, even if they are no longer employed by the agricultural employer, but were employed during the period when the information was required to be displayed and maintained. The agricultural employer must provide access to, or a copy of, the requested information applicable to the worker's or handler's time of employment on the establishment within 15 days after receiving any such request. Workers and handlers must make the request orally or in writing. If the request is made Through a designated representative, the request must contain a written statement clearly designating the representative to request pesticide application and hazard information on the worker's or handler's behalf. The request should include the worker's or handler's printed name and signature, the date of the designation, and the printed name and contact information for the designated representative. Anti-retaliation. Employers must not retaliate against a worker or handler who attempts to comply with the WPS, files a complaint, or provides information in an investigation of alleged WPS non-compliance. Decontamination supplies. The employer of the agricultural establishment is required to provide accessible decontamination supplies in a single location, within 1/4 mile of all workers and handlers. 1 gallon of water per worker and 3 gallons of water per handler at the beginning of each work period for routine and emergency decontamination. Plenty of soap and single-use towels. A clean coverall, or other clean change of clothes, for handlers. When a product requires protective eyewear for handlers, or when using a closed system under pressure, provide the following in mixing and loading areas: a system that can deliver gently running water at 0.4 gallons per minute for at least 15 minutes or 6 gallons of water in containers suitable for providing a gentle eye flush for about 15 minutes. When applying a product that requires protective eyewear, provide 1 pint of water per handler in portable containers that are immediately available to each handler. Definitions. Designated representative, any persons designated, in writing, by a worker or handler to exercise a right of access on behalf of the worker or handler to request and obtain a copy of the pesticide application and hazard information. Safety data sheets. SDS safety data sheets contain technical safety information about a pesticide. Restricted entry interval, REI. The restricted entry interval is the time immediately after a pesticide application when entry into the treated area is restricted. Worker, any person, including a self-employed person, who is employed and performs activities directly relating to the production of agricultural plants on an agricultural establishment. Handler, any person, including a self-employed person, who is employed by an agricultural employer or commercial pesticide handler employer and performs activities that put them at increased risk of direct exposure to pesticides, such as mixing, loading, or applying pesticides. Agricultural employer, any person who is an owner of, or is responsible for the management or condition of, an agricultural establishment, and who employs any worker or handler. Commercial pesticide handler, any person, other than an agricultural employer, who employs any handler to perform handler activities on the agricultural establishment. Application exclusion zone, AEZ. The area surrounding the application equipment that must be free of all persons other than appropriately trained and equipped handlers during pesticide applications. Personal protective equipment, PPE devices and apparel that are worn to protect the body from contact with pesticides or pesticide residues. Central posting location, a place on the agricultural establishment where workers and handlers are likely to pass by or congregate and where it can be easily seen and read, where the pesticide application and hazard information must be displayed. For more information, contact ODA at 503-986-4635, or Oregon OSHA. Oregon Department of Forestry, ODF. The ODF administers the Oregon Forest Practices Act, FPA, Chapter 527, Insect and Disease Control, ORS 527.610 to 527.99 and the Forest Chemical Rules, Division 629-620. 0000 through 629-620-0800, which protect water quality and other natural resources on state and private forest land. Anyone who conducts a commercial forest management activity, operators as defined by ODF, must notify the ODF at least 15 days before starting operations to allow time for cooperative discussion before activities begin. The FPA and forest practice chemical rules apply to any of the following activities that are part of the commercial growing and harvesting of forest trees: pesticide and fertilizer use, timber harvesting, road construction and maintenance, /treatment, and reforestation. In certain instances, buffers, no spray zones, near waterways may be required. In addition, 2015 legislation mandated buffers when applying herbicides by aircraft near an inhabited dwelling or school. For more information, contact ODF. Oregon Department of Transportation. Motor Carrier Transportation Division. The Motor Carrier Division regulates the transportation of hazardous materials including pesticides in Oregon, and enforces requirements for proper placarding of shipments of hazardous materials transported over public roads and highways. Contact the Motor Carrier Division for additional information. Oregon Emergency Response System, OERS. The purpose of the Oregon Emergency Response System, OERS, is to coordinate and manage state resources in emergencies involving multiple governmental agencies and the private sector. OERS is the cornerstone of the state emergency services system. While OERS responds to spills or releases of a reportable quantity of any hazardous material such as oil, pesticides, or any other hazardous material. Example of a type of reportable emergency. Any person owning or having control over any oil or hazardous material who has knowledge of a spill or release shall immediately notify the Office of Emergency Management as soon as that person knows the spill or release is a reportable quantity, ORS 466.635, DEQ statute. To activate OERS, local public safety agencies such as law enforcement, fire, and other emergency medical service providers will normally provide the first response to an incident, and are activated by calling 911. Responsible parties are also required to report spills and releases to OERS by calling 800-452-0311. OERS provides 24-hour service, 365 days a year. OERS was established in 1972 to allow for rapid and efficient response to hazardous material spills in the state. It is not an agency as such, but a group of agencies cooperating to provide information and expertise to those who must respond to hazardous material accidents and spills. By reporting spills and accidents involving pesticides and other hazardous materials through the OERS, all of the proper authorities are notified and dispatched to the scene. Call in Oregon, 800-452-0311. Call outside of Oregon, 503-378-4124. Oregon Health Authority, OHA, Public Health Division. OHA requires all healthcare providers, physicians, nurses, chiropractors, osteopaths, hospitals, etc., to report confirmed or suspected illnesses from pesticide exposure. Reports are made to the local health department or directly to the Public Health Division. The possible exposure incident is then reviewed and investigated by the appropriate agency or agencies. OHA works with the Oregon Poison Control Center to supply healthcare providers with information on pesticide products and on appropriate tests and medical care for exposed individuals. OHA compiles information on all cases and evaluates the cases for patterns of illness related to a particular chemical or application practices. The information gathered is used to make recommendations to the industry and applicators to prevent problems from reoccurring. Oregon Water Resources Department, OWRD. OWRD's authority to regulate backsiphon prevention devices comes from Oregon Revised Statute, ORS, 537.780, 1b, a. The requirements for backsiphon prevention devices is covered under Oregon Administrative Rule, or Chapter 690.215.017, 3, which require that backsiphon prevention equipment must be installed on any irrigation system connected to a ground water source when fertilizers or any other chemicals are applied through the system. The lack of properly functioning backsiphon devices in an irrigation system can result in contamination of groundwater sources. The landowner or other responsible parties are responsible for assuring that the backsiphon prevention equipment is installed and properly functioning. If you are planning to apply pesticides and/or fertilizers through irrigation or other water systems, see OR 690.215.017, 3, for regulations governing the use of groundwater and required equipment for chemigation. For more information, contact the Oregon Water Resources Department. Office of the State Fire Marshal, SFM. The Office of the State Fire Marshal administers the Oregon Community Right to Know and Protection Act, ORS 543.307 to ORS 453.520. This act has requirements for employers, owners and business operators who store hazardous substances at their fixed facilities at or above the threshold quantities, to report to the State Fire Marshal's office information about those substances. Some of the information required to be reported includes the identity of the substance, the amounts stored at the site, and the hazards associated with the substance. This information is available by hard copy or electronically to health authorities, the general public, federal, and state agencies, firefighters, and other emergency personnel who might need to respond to an emergency at the facility. For additional information regarding the Community Right to Know Act or specific requirements. For more information on the minimum reportable quantities, and other community right to know laws, contact the State Fire Marshal's office.